Hi, this is our screencast. It's the third of the voiceovers that I'm doing, and this one is on the brief of the appellant. I'm going to divide this into two parts, so there'll be two separate voiceovers, one on the notice part of the question and the other on the undue burden part of the question. So again, the key thing here is, remember, once we're into the case that we talked about in video in the second screencast, and now this one, you're basically reading the part of the question you're on. So Roman numeral 1 deals with the notification. Was Abercrombie and Fitch legally notified, as we've defined it before, of Elof's religious concern about wearing her head covering? And so you can kind of just go through this and you can see what the burden of proof is. And here, you got to remember that you're dealing with Abercrombie and Fitch, and so they are looking at a very narrow definition of what it means to inform. You're going to use the Thomas versus National Association of Letter Carriers quite frequently in your arguments. Excuse me. And you'll see that there's actually a separate, the entire case is in the second set of documents that you'll have that we'll talk about later. And so, key thing, and we talked about this before, when you're arguing the Abercrombie side of this, you're going to stick to a very literal definition of what it means to inform. And the key thing here is there's no doubt that Elof did not bring up her religious concern about wearing head coverings and how that might violate the quote-unquote look policy during her interview. And so basically this brief does a nice job of going through and talking about several parts under this issue. So you can see that number one, Title VII of the Civil Rights Act basically puts the burden on the employee to inform the employer. And what you want to do from this point on, if you're arguing this side of the case and this question, is you want to look for precedent and reasoning that supports your argument that the court should adopt a very narrow definition of what that means. And you can see that as you move to the second page, there are several cases that they're citing. You certainly don't need to cite all of those cases. But the key argument that they're making, as you'll see, is that in order for Abercrombie to be notified, Elof had to take some kind of affirmative action to make that notification. Again, your job is, at least in part, and you can certainly make other arguments, but your job is at least in part to say that she did not meet that burden because she did not bring it up herself. And you can see as you're going on through, there's a lot of arguments in this favor. Then this is, when you get to number 2, this is pretty much a repeat of what we've just talked about. Again, the key thing is that the testimony shows that Elof did not say anything about her religious belief in the interview, and so Abercrombie is arguing that the earlier court should not have given what's called a summary judgment, meaning they should have disagreed with her on that, or there should have been more investigation by the court of that claim. Again, remember, as you're going through this, those of you that are doing this question are going to argue it on the other side, and remember that Elof and the EEOC are going to be arguing that clearly they did know she was a Muslim. Clearly they did know Elof was wearing head covers because of her Muslim religion, because that's what Gannett, the person who interviewed her, actually said. But the key thing here is focusing on the case law and the reasoning that supports the idea that in order for that notice to happen, Elof had to make a clear indication in the interview that that was an issue that she was concerned about. And, you know, as you're going through this, I want to be clear. You're looking for cases that back up your interpretation of what it means to be noticed here. And you're also making some reasoning. Again, you can see as you're going through that one of the things that Abercrombie does is to make an argument that if employers have to figure out whether an employee has a religious concern about a particular policy, that this is putting too much of a burden on employers to interpret these religious issues. And continuing to move through, and again, I'm assuming you can read this on your own. And here's where you're getting to towards the end of this part of the brief, when they're really talking about reasoning. And here you can see that they're very concerned about if you allow this notice to stand, where Eloff did not have to tell Abercrombie and Finch that she had a religious issue, that this could open all sorts of negative things in the future. So I'm especially looking here that part of the reason they wanted Eloff to have to do the notification would be to avoid unfair surprise to an employer. And they talk in here about how employers are really discouraged from asking religious-based questions. If you put the burden on the employer to do all this interpreting, maybe they would start to ask questions that would actually harm people's religious freedom later on. But again, I'm allowing you to read the briefs. What I'm telling you about the first part of the brief, if you are doing the notice part of the question, that what you want to be focusing on are cases and reasoning that supports Abercrombie's position that Abercrombie was not notified because Eloff did not make that direct notification. And so we're going to go ahead and stop there, and then I'll deal with the undue burden standard in the next screencast that we produce.